my name's Luann Donald and welcome to our Spring 2011 Employment Law Update for local authorities. We've got quite an interesting range of topics to cover today, including a case about volunteer rights, and that's caught our eye because the government's been very interested recently in us using more volunteers. We're also going to talk about the new public sector duties coming out under the Equality Act and what we have to do to get ready for workforce data publishing. And we've also got a new government consultation that Phil's going to talk us through, and the proposals are aiming to reform the employment tribunal system and to help employers to resolve workforce disputes before they even get to that stage. So we'll look at what kind of questions the government's asking. So Phil, what's this consultation about and what should local authorities look out for?
Ultimately, it's about ways of reducing burdens on employers in terms of workplace disputes. What it's doing is looking at ways of encouraging workplace mediation, looking at ways of steps that employees have to take before they can bring an employment tribunal claim, and then ultimately looking at streamlining the tribunal system itself. Now, if some of the proposals go ahead, they'll have a very real impact on employers in terms of their duties to their employees. I'm thinking here of the proposal to increase the qualifying period for unfair dismissal from 1 year to 2 years, but there'll also be potentially a substantial cost impact on employers if the proposal to introduce automatic financial penalties is introduced.
You mentioned one of the key aims is about preventing disputes ending up in a tribunal, and that sounds really good. So how did the government propose to do this?
One of the proposals is to encourage workplace mediation, but there's also a proposal for a compulsory pre-claim conciliation process. What this means is that before an individual can bring an employment tribunal claim, they've got to submit details of that to ACAS, and then there's then this 1 month conciliation period during which hopefully ACAS can sort an agreed settlement out between the parties. Now, if that doesn't happen, the individual's then allowed to submit their claim to an employment tribunal. Now, what this means is that local authorities will need to be ready to participate in conciliation at an early stage. But they also shouldn't forget that if these claims do end up in an employment tribunal, there are some proposals to try and streamline that process. One of those being that some unfair dismissal claims could be heard by an employment judge alone, rather than a panel of 3 members.
What is it about the proposed financial penalties that local authorities need to pay attention to?
The idea behind these financial penalties is that it will try to encourage employers to comply with the law. And the way that they'll work is that where an award is made to an individual, if there's a breach of an employment tribunal right, then the employer has to pay 50% of that award as a penalty. So say an individual gets £3,000 as an award, there'll be a financial penalty of £1,500, and that's payable to the taxman. Now, the proposals say that there will be exceptional cases where the penalties wouldn't apply, and they give the example of multiple large-scale claims. Now, we would say that the type of claims that fall into that category are mass equal pay claims against one authority. So if these proposals do go ahead, we in local government will want to make sure that any guidance on penalties makes it clear that mass equal pay claims should be exempt from the penalties.
These are only proposals at the moment, Phil, so what can local authorities do if they want to comment on them?
Well, if people want to take part in the consultation, they can send their comments to us and we can include them in our response to the government. And details of how to do that are on the website and also in the February Advisory Bulletin. What we've done as well to make it easy for authorities to take part in the consultation is produced a shortened version of the consultation questions, which is also in the consultation section of the website. And what I'd like to stress, Luann, is that authorities don't have to answer all those questions. If they only want to answer 1 or 2, that's fine. Just send them to us. And finally, just to wrap up, it's worth remembering that the consultation document talks about proposed fees for tribunal users, and there will be a consultation on that in the near future, so people should keep an eye out for that. So Luann, a recent case about a volunteer in a Citizens Advice Bureau caught our eye because it's about the rights and protections for volunteers in the workplace. So what are those rights and protections for volunteers?
Phil, the place to start is to recognise that volunteers are not employees and they don't have the same rights and protections that employees have. Unfortunately, this case didn't supply all the answers, so to work out what rights and protections volunteers do have. We need to look at what the volunteering arrangement is, the exact details of it, and what the purpose of the volunteering is.
So what you're saying is there's no simple answer really. So how does this case help us then?
This case helps us because it looked at a particular type of volunteer arrangement and examined what the characteristics of that arrangement were to work out whether the individual was covered by disability discrimination legislation. For this particular case, because of how the volunteer arrangement was set up, it was decided that the individual wasn't protected by the discrimination law.
So can you tell us a bit more about the details of the case?
This volunteer was an advisor in a CAB branch, and although they work in a way that has a set number of hours they expected her to do, she could pretty much come and go as she pleased. But there came a time when the CAB needed to end the arrangement, and the volunteer claimed that that was because of her disability, so she claimed disability discrimination. The big question for the tribunal was whether the volunteer was actually covered by the legislation for disability discrimination.
So what exactly did the EAT look at?
The Employment Appeal Tribunal looked at three things to try and decide whether the individual was covered. And the first of that was to look at the UK and the European legislation. And they decided that the legislation is designed primarily for employees, and the volunteer was clearly not an employee. The legislation does, however, include some other categories of workers and individuals. For example, it includes work placements. So that was the second thing they looked at, was whether the volunteering arrangement could qualify as a work placement. But again, they decided that it didn't qualify for that because the legislation is really clear that the work placement is for a limited time and the purpose of it is training, whereas the purpose of this volunteer was to give advice. So she didn't meet that category either. The third thing they looked at was whether the volunteering could be classed as an occupation, and they decided no, it didn't. Although the legislation allows for an occupation or a qualification for work, the volunteering didn't come under that, didn't meet that definition because it has unpaid status. So they looked across the three main characteristics and decided that the legislation didn't cover her and she wasn't protected as a volunteer under the disability discrimination legislation.
So Luann, from what you've said, different types of volunteers attract different types of rights.
That's correct, Phil. Not all volunteers have the same rights. For example, the age discrimination legislation applies to everyone. It's a universal right, but other types of discrimination don't. So employers shouldn't assume that everyone gets everything, even though the European law and the UK law is quite heavily prescribed for discrimination legislation. It doesn't apply across the board. But saying that, we should remember local authorities have some additional responsibilities. For example, under the new public sector duties in the Equality Act, we have some guidance in there about how we should be treating employees, workers and other individuals. And also we have policies such as fairness and dignity and those kind of things that prescribe how we treat people who work for us and with us. So we've got quite a comprehensive framework in local authorities that help us to understand how we treat volunteers, and we shouldn't just rely on the law. Phil, our last topic is about the new Equality Act public sector duties that are coming in on the 6th of April 2011 and the workforce data publishing requirements that come out under that. Let's face it, that hardly sounds exciting. Why are we doing this? What's it for?
Well, the important thing to remember is it's all about gathering information so that employers can understand where they are in relation to equality issues in their workforce and where they need to get to. And they can publish that information in a transparent way so their workforce and the people in their area can understand where they are as well. So although it doesn't sound very interesting, actually in practice what it can give to you is very useful.
So now we understand how this can help us, but can you tell us what we actually have to do under the new duty?
What it does is place a general requirement on public bodies to do three things. The first of them is to eliminate discrimination, the second is to advance equality of opportunity, and the third is to foster good relations between the different protected groups. Now, this new equality duty is a single one and replaces the three current ones we have for age, sex and disability, and it applies to all the protected characteristics. So we're also looking at things like sexual orientation and religion and belief. But under that general duty, there's some legislation that sets out specific things that public bodies have to do. And one of them is that employers with more than 150 employees must publish workforce data.
So what information do local authorities have to publish?
The legislation itself does not actually say what has to be published exactly, but what the Equality and Human Rights Commission have done is publish some guides that set out what you would expect to see published, and if authorities follow those guides, then they can say, yes, we're complying with the workforce equality duty reporting requirements. Now, the type of information the Commission say that we should be publishing is information on the distribution in the workforce in terms of race, gender, disability and age, but also look at the likely representation in the workforce in terms of sexual orientation and religion and belief. They also say it would be good if public bodies could publish information on take-up of training, recruitment, promotions in terms of the different protected characteristics.
When does this information have to be published and how?
Apart from schools, public bodies have until 31st July this year to publish the information. Schools have until the end of this year, and then once it's been published, it must be updated annually. Now, in terms of how it's published, the EHRC suggests that it could be on websites, could be in annual reports, and also they say you should have a look at the Cabinet Office guidance on transparency and publishing information.
Phil, what steps can local authorities take to prepare for publishing this data?
The first thing to do is to read the Equality and Human Rights Commission guides and see what information you do have under those guides and what you're going to need to start collecting, and set and plan a process for collecting that further information. You should also speak to the people in your authorities who publish information, such as your web teams, people who publish reports, and they'll be able to help you produce this information in an accessible format. But at the end of the day, Luann, what I want to stress again is that this isn't just about facts and figures. It's about helping authorities compile a profile of their workforce in terms of equality issues and helping them understand how their policies and procedures impact on different groups and how they're meeting the equality duties.
Thank you for watching. As always, you can find out more information about all of the topics we've talked about today on our website or in our advisory bulletins. You might also be interested in attending the workforce efficiency events that are taking place around the country, and you can find more details of those on our website on the events section. But until next time, goodbye.